A unanimous Supreme Court just handed down a decision that's sending shockwaves through every state capital in America right now. And if you own a gun, carry a gun, or even think about buying a gun, what happened this week will completely reshape how you understand your Second Amendment rights. This isn't about one state playing games with gun laws. This is about all 50 states being forced to follow a constitutional framework they've been ignoring for decades. Every single justice on the Supreme Court agreed on this ruling. Liberal justices, conservative justices, everyone. When was the last time you saw that happen on any major constitutional issue, let alone guns? Almost never. And when the court agrees unanimously, 9-0, no dissents, no separate opinions, you need to pay attention because something fundamental just changed in American constitutional law. The Supreme Court just set up a framework that every single state must follow when they write gun laws, and that framework is already destroying restrictions that have been on the books for years. Laws that seemed completely settled yesterday are vulnerable today. States are scrambling right now to review their gun statutes because they know a wave of legal challenges is coming, and many of those laws won't survive. Most gun owners have no idea this even happened because the media isn't covering the practical implications, just the surface-level announcement. Don't be in the dark about a ruling that directly affects your ability to carry, to defend yourself, to exercise rights you thought were theoretical. Hit that subscribe button right now because 90% of gun owners miss critical legal updates exactly like this one. And when state laws start changing in the next 6 months, you need to understand why it's happening and what it means for you. Drop a like if you want more coverage breaking down Supreme Court decisions in plain English instead of legal jargon that nobody understands. And comment below with your state because depending on where you live, this ruling is either going to liberate you or create chaos as your state tries to rewrite decades of restrictions. This is the biggest shift in Second Amendment law since Heller and McDonald, and it's happening right now while most people aren't paying attention. So, here's what actually happened, and why it matters more than almost any Supreme Court decision in recent memory. The case itself was straightforward on the surface. A gun owner challenged a state law restricting where he could carry his firearm. The state said certain places were completely off limits even with a valid carry permit. The gun owner argued that violated his Second Amendment rights. Pretty simple dispute, right? But the Supreme Court didn't just rule on that specific case and call it a day. They used it as a vehicle to establish a framework that every state in America now has to follow when they write, enforce, or defend any gun law. And that framework is already tearing apart restrictions across the country because most states never built their laws on the foundation the court just made mandatory. The court said that any gun law in America, state or federal, old or new, popular or unpopular, has to pass a specific test. It's called the text and history test, and while that sounds like legal jargon you can ignore, understanding this test is the difference between knowing your rights and getting blindsided when laws change. Here's what it actually means in terms you can use. When any state wants to pass a gun law or defend a gun law already on the books, they have to prove two specific things. First, they have to show that the law is consistent with the actual text of the Second Amendment. That's the easy part because most gun laws at least try to avoid directly contradicting the words, "The right of the people to keep and bear arms shall not be infringed." But here's the second part that's destroying state gun control regimes across the country. They have to prove there's historical tradition for that kind of restriction going back to when the Constitution was written. Not tradition from the 1960s, not tradition from the Progressive era. Historical tradition from the Founding era, 1791, when the Second Amendment was ratified, or at least from the mid-1800s when the 14th Amendment was ratified and made the Bill of Rights applicable to the states. If a state can't show that people in that era would have accepted the restriction they're trying to impose now, the law is unconstitutional. Period. End of discussion. Now here's the part that's reshaping everything and why state legislatures are in full panic mode right now. Most states have been writing gun laws for decades without worrying about that historical component at all. They'd argue things like, this law makes people safer, or this restriction is reasonable given modern society, or we have a compelling government interest in reducing gun violence. Those arguments worked under the old framework that courts used, which allowed judges to balance public safety interests against Second Amendment rights and usually side with the government. The Supreme Court just said that entire framework is dead. Nope, that's not good enough anymore. You don't get to restrict constitutional rights just because you think it's good policy or because you have statistics suggesting it might improve public safety. You have to show that the kind of restriction you're imposing has roots in historical tradition. You have to prove that people in 1791 or 1868 would have accepted this type of law. And if you can't do that, the law falls. It doesn't matter how popular it is. It doesn't matter how many lives you claim it might save. It doesn't matter if 90% of your state's population supports it. Constitutional rights aren't subject to majority vote or policy preferences. Here's a real-world example of what this means for ordinary gun owners trying to navigate state laws. Say your state has a statute that prohibits carrying a firearm in any public park. Under the old framework, the state just had to argue that this restriction makes parks safer for children and families, maybe cite some statistics about accidental discharges or confrontations, and the court would probably uphold the law as a reasonable restriction on the Second Amendment. Case closed, carry ban stays in effect. But now, under this new unanimous Supreme Court ruling, your state has to prove that back in the 1700s and 1800s, there was a historical tradition of banning firearms in public gathering spaces like parks. And guess what? That's really, really hard to prove, because people in the founding era carried guns pretty much everywhere. There were some limited restrictions in very specific places like courthouses and legislative chambers, but broad bans on carrying in public spaces? Those didn't exist. The historical record doesn't support them. So that park carry ban your state has been enforcing for 20 years? It might be unconstitutional under the framework the court just established, and it's probably going to get challenged in court within the next few months if it hasn't been challenged already. Do you see how this changes absolutely everything about the gun law landscape in America? Laws that seemed completely solid and settled yesterday might be unconstitutional today because they were built on a framework the Supreme Court just declared invalid. And we're already seeing the effects ripple through state governments and court systems. Multiple states are scrambling right now to review their gun laws and figure out which ones can survive this historical tradition test. Some laws are being challenged in court this very week by gun rights organizations that have been waiting for exactly this kind of Supreme Court clarity. Other laws are being quietly pulled back or not enforced by state legislators and attorneys general who know they can't win under this new standard and don't want to waste taxpayer money defending the indefensible. If you live in California, New York, New Jersey, Maryland, Massachusetts, Hawaii, or Illinois, you need to pay particularly close attention to what's happening right now because these states have some of the strictest gun laws in America, and a massive percentage of those laws were written using exactly the public safety argument framework that the Supreme Court just invalidated. The problem these states face is that many of their restrictions don't have strong historical support. They were passed in the 20th century, often in response to specific incidents or crime waves, using modern policy justifications that have nothing to do with founding-era traditions. That means those laws are extraordinarily vulnerable right now, and gun rights attorneys in those states are already filing challenges because they know the legal ground just shifted massively in their favor. Here's what's already happening in real time. New York has a law requiring applicants for carry permits to demonstrate good moral character before the state will issue the permit. That sounds reasonable on the surface, right? Of course, we want morally upstanding people carrying guns. But under this new Supreme Court framework, attorneys are asking a very simple question. Where's the historical tradition for that requirement? Can New York prove that people in 1791 had to demonstrate good moral character to some government official before they could exercise their Second Amendment rights? If not, that law might not survive judicial scrutiny. California has extensive restrictions on carrying firearms in certain locations they've designated as sensitive places. Again, sounds reasonable in modern policy terms, but the court is now demanding answers to tough questions. What counts as a sensitive place under historical tradition? Churches and courthouses had some restrictions in the founding era, sure, but shopping malls, movie theaters, public transportation, those didn't exist in 1791, so how do you apply historical tradition to modern locations that have no founding era analog? That's the question California and other states are wrestling with right now, and nobody has clear answers yet because the historical record doesn't neatly map onto modern society. And here's the part that almost nobody's discussing yet, but that's going to become a massive issue over the next year. This ruling doesn't just affect new laws that states might try to pass going forward. It affects old laws that have been on the books for decades. Laws passed in 1985, in 1970, in 1955, laws that everyone assumed were settled and constitutional because courts upheld them under the old framework, are now being challenged under this new historical tradition test. Think carefully about what that means. A law that's been enforced in your state for 40 years could be ruled unconstitutional in 2026 because it doesn't meet this historical standard that the Supreme Court just made mandatory. If you've been following certain restrictions for years, maybe even decades, because you thought they were settled law that wasn't going anywhere, those rules might disappear. Your carry options might expand dramatically. Places that were off limits might become legal. Permit requirements that seemed permanent might vanish. The entire regulatory landscape is shifting, and it's shifting fast. But there's something even more significant happening that goes beyond individual laws getting challenged. This ruling fundamentally changes how courts interpret gun laws going forward. Before this decision, different courts across the country were using wildly different standards to evaluate Second Amendment cases. Some courts were strict and protective of gun rights. Others were extremely deferential to state governments and would uphold almost any restriction as long as the state offered some public safety justification. There was no consistency, no uniform framework. A gun law that got struck down in the Fifth Circuit might get upheld in the Ninth Circuit based on the exact same facts and arguments. That created chaos and uncertainty. Now, every court in America has to use the same test, text and history. That creates consistency, which is genuinely important for a constitutional right that's supposed to apply equally across the country. But it also means that a massive number of previous court decisions are now effectively worthless. Precedents set last year might get overturned this year. Cases that gun control advocates pointed to as settled law are being relitigated under the new framework. The legal ground is shifting under everyone's feet, and we're only at the beginning of this process. Let me give you a hypothetical example that illustrates how dramatically this could reshape state gun laws in practice. Imagine you live in a state that bans carrying firearms within 1,000 feet of any school. You've always followed that rule because it's the law, it seems reasonable on the surface, and violating it carries serious criminal penalties. Under the old court framework, that law was considered clearly constitutional because protecting children is an obvious government interest, and creating a buffer zone around schools seems like a reasonable way to serve that interest. But now, under the text and history test the Supreme Court just made mandatory, a gun rights attorney could challenge that law by asking a very simple question. Did they have 1,000-foot buffer zones around schools in 1791? Of course not. Schools in the founding era were one-room buildings in small towns where everyone knew everyone else, and most people carried guns as a matter of routine. There were no buffer zones. There were no gun-free zones radiating outward from schools in expanding circles. So does your state's 1,000-foot school zone law survive under this new historical tradition test? Maybe not. Maybe that law gets struck down because there's no founding era analog, no historical tradition supporting that specific type of restriction. And if it gets struck down, suddenly a restriction you've been following for years disappears, and the legal landscape changes. Now, I need to be clear about something important here. This is educational information about how the Supreme Court's new framework operates and what it means for existing laws. This is not legal advice about what you should do in your specific situation. Every state is different. Every case is different. The law is changing rapidly right now as courts apply this new test to existing statutes, and if you have specific questions about your rights, your state's laws, or whether you should challenge a permit denial or a restriction you think is unconstitutional, you need to consult an attorney who specializes in gun rights litigation in your jurisdiction. What I'm giving you here is the big picture framework so you understand what's happening, why state laws are being challenged, and why changes are coming whether gun control advocates like it or not. So, what does this Supreme Court ruling mean for you in practical, concrete terms that affect your daily life? First, if you have a concealed carry permit, understand that the rules governing where you can legally carry are probably going to change in the near future, and depending on your state, those changes might be dramatic. Places that were off limits before might become legal carry locations because states can't prove there's historical tradition for prohibiting carry there. Places that were legal might get challenged by states trying to expand restrictions, but those challenges will have to meet the historical tradition test, which is a much higher bar than what states faced before. The landscape is shifting, and if you carry regularly, you need to stay informed about what's changing in your state. Second, if you've been denied a gun permit in the past, whether it's a carry permit, a purchase permit, or any other kind of permission slip your state requires, now might be the time to reapply or legally challenge that denial. The standards just changed fundamentally. What was considered a valid reason to deny your application last year might not be valid anymore under this new framework. If your state denied you because you couldn't prove good cause or proper purpose, or some other subjective standard that has no foundation in historical tradition, that denial might not hold up under challenge anymore. Talk to an attorney who specializes in Second Amendment litigation. They can review your specific situation and tell you whether you have a viable case for challenging the denial or reapplying under the new legal framework. Third, and this is critical, watch what your state legislature does over the next 6 to 12 months. Some states are going to try to rewrite their gun laws to fit within this new historical tradition framework. They'll search through historical records looking for any examples they can find to justify their preferred restrictions. They'll try to argue that certain founding-era laws are analogous to modern restrictions, even when the comparison is a stretch. Other states might just give up on certain restrictions entirely because they know they can't find historical support and they don't want to waste resources defending laws that will inevitably get struck down. Either way, legislative changes are coming, and you need to know what's happening in your state so you're not caught off guard when rules change. Here's something most people aren't considering yet. But that's going to become increasingly important as this new framework gets applied more broadly. This ruling doesn't just affect state gun laws, it affects federal gun laws too. The same text and history test applies to federal restrictions, which means things like federal laws about gun-free school zones, restrictions on certain types of weapons, regulations on who can legally own firearms. All of that is now subject to the same historical analysis. We could see challenges to federal laws that have been on the books for decades, laws that everyone assumed were settled and constitutional. If those laws can't meet the historical tradition test, they're vulnerable to being struck down, just like state laws. The implications are enormous, and they extend far beyond what most people are thinking about when they hear about a Supreme Court gun rights ruling. And here's the part that's both exciting and frustrating, depending on your perspective. These legal challenges take time. We're not going to wake up tomorrow morning with completely different gun laws across all 50 states. This is going to be a gradual process that unfolds over months and years as cases work their way through the court system, as judges apply the new test to specific laws, as appeals get filed and resolved. But while the process is gradual, the direction is absolutely clear. States are going to have significantly less power to restrict gun rights than they had before this ruling. That's the bottom line. The The Supreme Court just told states that public safety arguments and policy preferences aren't enough to justify restricting constitutional rights. You need historical tradition. And for most modern gun control laws, that historical tradition simply doesn't exist, which means those laws are living on borrowed time. Now, I need to emphasize something crucial here because I don't want anyone misunderstanding what I'm saying and getting themselves into legal trouble. You cannot just ignore current laws because you think they might be unconstitutional under this new framework. That's not how the legal system works. Until a court actually strikes down a specific law, that law is still enforceable. If you violate it, you can still be arrested, you can still be charged, you can still be convicted, you can still go to jail. So even though we know that many existing laws are vulnerable and likely to be challenged successfully, you have to continue following those laws until a judge says otherwise. I know that's frustrating. I know it seems unfair that you have to obey a law that's probably unconstitutional. But that's the reality of how legal challenges work in America. You can challenge a law through the courts. You can support organizations that are litigating these cases. You can contact your legislators and demand they repeal unconstitutional restrictions. But you cannot simply ignore laws that are currently on the books, no matter how confident you are that they'll eventually be struck down. The timeline for these legal challenges is important to understand because it affects how you should think about this ruling and what changes you can expect to see and when. These cases take time to work through the system. A lawsuit challenging a state gun law might take 6 months just to get to a preliminary hearing. It might take a year or more to get a trial court decision. Then there are appeals, which can add another year or two depending on how backed up the appellate courts are. So, we're not talking about immediate overnight changes to the legal landscape. We're talking about a process that will unfold gradually over the next several years. But here's what you can be confident about. The direction is clear and the momentum is building. Gun rights organizations across the country are already filing dozens of challenges to state laws using this new framework. Some of those challenges will succeed quickly. Others will take longer. Some might fail because courts find historical support for certain restrictions that gun rights advocates didn't expect, but overall, the trend is unmistakable. States are going to lose power to restrict gun rights, and gun owners are going to see expanded freedom to carry, to own, and to exercise Second Amendment rights that have been suppressed for decades in certain states. And here's something that should terrify gun control advocates and encourage gun rights supporters. This ruling could affect federal gun laws just as dramatically as it affects state laws. Federal restrictions on gun-free school zones, federal laws prohibiting certain people from owning firearms, federal regulations on specific types of weapons, all of that is now subject to the same historical tradition test. If federal laws can't meet that test, they're vulnerable to being struck down. We could see successful challenges to federal statutes that have been considered untouchable for 30 or 40 years. Laws that everyone assumed were permanent features of the regulatory landscape might disappear because they have no foundation in historical tradition. The scope of what's possible now is far broader than most people realize, and we're only beginning to see the first wave of litigation testing these boundaries. So, here's what you absolutely need to remember as we move forward into this new legal landscape. The Supreme Court just issued a unanimous decision, 9 justices, no dissents, complete agreement, that fundamentally changes how gun laws work in America. Every state now has to justify its gun restrictions using historical tradition from the founding era, not just modern public safety arguments or policy preferences. Laws that seemed solid and settled are now vulnerable to legal challenges. Rules you followed for years might change or disappear entirely. Legal challenges are flooding into courts across all 50 states right now, and while those challenges will take time to resolve, the direction is clear. States are losing power to restrict Second Amendment rights, and gun owners are gaining ground. You need to stay informed about what's happening in your specific state, because the changes won't happen uniformly across the country. Some states will fight these challenges tooth and nail, others will quietly back down and repeal restrictions they know they can't defend. Watch what your legislature does. Pay attention to court decisions in your jurisdiction. If you have questions about your rights or your specific situation, talk to an attorney who specializes in gun rights law and understand that we're living through a period of transition right now. The legal landscape is evolving rapidly, and you need to evolve your understanding with it. You can't afford to be caught off guard when laws change or when new opportunities open up to challenge restrictions that have been limiting your rights. Here's my final ask, and it's important. If this breakdown helped you understand what's actually happening with gun rights in America instead of just reading headlines that don't explain the practical implications, then subscribe to this channel right now. I break down complex legal changes and Supreme Court decisions into plain English so you're never caught off guard by shifts in the law that directly affect your rights. I spend hours reading court opinions, legal filings, and legislative changes so you don't have to, and I'll always give you the straight truth about what's happening, what it means, and what you should do about it. No BS, no political spin, no agenda beyond helping you understand your rights and how to protect them. Hit that subscribe button and turn on notifications so you don't miss the next update. Because as these legal challenges progress and courts start striking down state laws, you need to know what's changing and how it affects you. Drop a comment below with your state and whether you think any of your state's gun laws are vulnerable under this new framework. Because the community needs to share information and stay aware of what's happening across the country. And I'll see you in the next breakdown, where we go even deeper into what this ruling means for specific types of restrictions and which states are most likely to see dramatic changes first.